I know it's not a debate format, but what actually happened was, respectfully,
we're all friends here. You
we
should
are.
know that.
We really are. I have a great deal of
See,
respect.
if we just had one side here, this would
Yeah.
be terrible, right? Let's go.
So it's true that the statement was suppressed, and Judge Barry ruled that it was a violation of Christopher's rights. Essentially, what happened was Chris came home from Rochester. He was met at the hospital by the Bethlehem Police, who asked him to come to the police station. He agreed to do that. He walked with them. They stopped at Dunkin' Donuts, which was kind of the butt of some jokes, but then they proceeded on to the Bethlehem Police Department. Mike and I were there at the Bethlehem Police Department when Chris came. We were not in the interview room, but we were there. And while they were questioning Chris, who sat down, he said, he was very charming and he agreed to answer all their questions. While that was happening, Mr. Polster showed up at the front desk. And one of the lieutenants came to us to ask for some advice and said, there's someone here saying he's Chris's lawyer. What do we do? Do we have to let him back? And we said, it's up to Chris to decide who his lawyer is. Someone cannot unilaterally enter on his behalf. Go ask Chris if this guy is his lawyer or not. So they didn't quite do what we asked them to do. What they did was they went back in and they said, hey, that guy John at the hospital, is he your lawyer? And Chris said, no, he's a friend of my dad's. I don't think he could even be my lawyer. He's a good friend of my dad's. Okay, so are you okay speaking to us? Yeah, I'm fine. I'm fine speaking to you. And what the judge ruled was that was not enough. The police should have been more clear that there's someone here saying he's your lawyer. Do you want him as your lawyer or not? And they didn't do that. So that's why it was suppressed. But yeah, that interview was kind of long, and it was essentially Chris gave an alibi, and he was asked where he was that night, and he said, I was sleeping in the lounge of my dorm all night. And that was really the crux of what he said. He said some other gems in there, which we would have loved to have at the trial, but we didn't. And, throughout the trial, there were arguments that, this fruit of the poisonous tree argument, which is that based on this unlawful interview, the people have built their entire case around that. We were lucky enough that Chris told that same story to everybody, not just the police. He told it to his uncle when his uncle came to pick him up. I slept in the lounge all night. He told it to all his friends. He repeatedly told people at the hospital, where were you, Chris? I was at school. I was sleeping in the lounge all night. And we, while Chris was being interviewed, there were people there were Bethlehem Police at the school interviewing people in the dorm who all said, unluckily for Chris, they all, for some reason that Sunday night, sat up watching a movie in the lounge, a whole group of kids, Shrek 2, I remember the name of the movie. And they all said, Porco wasn't here. Porco was not in the lounge.
He had given up his bed right to his fraternity president who was visiting. And so he thought, okay, I'm going to be on the couch in the lounge. And,
and what he didn't know is that everybody else was there as well.
Mm-hmm. So as the investigation goes on, you start interviewing the students and building the timeline, breaking down the alibi or whatever. Then I think it was a few months later. In the meantime, what you have is Paul Klein, who's the DA, is lame duck. He lost the election that month in November. And so now you're dealing with an incoming new district attorney. I don't think that affected you too much. I couldn't tell. We were wondering how that might affect this case or the handling of this case. But a few months in, we write a story in February, a few months after the homicide, the investigation is ongoing, and there's trouble because there's a meeting and it's determined that the 40-member police force has taken on a monster here in terms of the breadth of this case, the work that's needed to do this. And so the state police, it's decided, are going to take a more leadership role, or at least get more involved. And is that where the leads start getting hunted down in terms of the prior burglaries at the house and things? Because remember, this is in 2002. There's a burglary at the house. Chris was home for Thanksgiving that weekend, and a front screen, I believe, was cut. The window was entered. A laptop was stolen from, I think, Joan. It was her laptop, and that's a crime that the Bethlehem Police just, hey, we'll never solve that. They didn't do anything. But now you fast forward, and the state police solved that crime in some respects, right? They traced the sale of that laptop to out of state and back to an eBay account, owned by Christopher. And so, anyway, tell me a little bit. Tell me a little bit about the state police coming in and how that changed the dynamic a little bit.
Yeah, the state police, they have a forensic unit, then they have a major crimes unit. And the forensic unit was there immediately, and they helped process the scene. But the major crimes unit was not called in till much later. And, Mike can probably talk more about that as well, but that was really when a team was put together, and they have what's called a lead desk, and they have, everything's computerized, and they start dispatching people, hunting down various leads. And, that's right. We did get the state police
Yeah,
involved.
I mean, it became obvious fairly early that the majority of the leads that needed to be investigated were not in the capital region, were not in Delmar, right? They were leads in Rochester. They were leads that had to do with, processing and finding, retrieving electronic data, school witnesses that were friends of his at school who were from all over the country, so during the breaks and stuff, they were all over the place. So it quickly became obvious that this was a very, very large in scope investigation that was better suited to an organization like the state police that has members everywhere. So people from Bethlehem weren't driving out to Rochester every day. There's troopers out in Rochester who can go and canvass areas and look for videos and interview witnesses. They were an immense asset to this. But the Bethlehem, never really gave up participation in the case. But they only have a handful of detectives who worked on the case, constantly, in addition to all the state police assets that were brought to bear on it.
And so early on, it was apparent to me in the hospital, Terry, that the family was a broken unit almost immediately. Because I remember sitting outside the ICU and I would watch Chris's sitting here and I would see members of who I would later learn were Joan's relatives or Peter's relatives going down the hall and having whispered conversations. And, they're because I think he's already been identified, right, as, the suspect. And so now they're all uneasy with his presence. And so at some point you get brought in and is that a difficult thing to deal with, when you've got...
Well, it certainly was my impression that there was a split in the family, that Peter's sister, who's passed away, I believe, but
Keep that mic up.
she was,
You need the mic.
she was, Peter's sister was one of the people in the family who was outwardly hostile toward him. And, that established terrain that was sort of treacherous for us because we didn't know who to talk to or what to talk to them about or what questions to ask or anything of that nature. So yeah, the family was definitely shattered from the start, no question about it.
Can I just respond to about calling in the state police?
Sure.
One of the things, again, that I think is really important for citizens to understand is the differential in power and resources between prosecutors and defense attorneys. I don't know how much the state police, the investigation cost. I don't know how much. I think, weren't you just pretty much working on the case?
Almost exclusively
so,
for a year, yeah.
And I know Dave gets paid a lot.
He's worth every penny.
And worth every penny. But the fact is that they had a war room, they had unlimited resources, they had expert witnesses, they had people who could go out. I mean, these same witnesses that Mike was talking about that are all over the nation, and all of the technology and all of those things, we needed that stuff too. But we couldn't pick up the phone and say to a trooper, can you go down to Florida because we think that there might be some witnesses there? Oh no, we don't have any money, but I'm sure you'll just want to do it because you want to know the truth. And so we were in a situation where basically the prosecution had unlimited funds, unlimited resources, unlimited assets, and we were trying to compete with that. And, that's one of the concerns. I teach at the law school. It's my 27th year, and I talk to students all the time about, they'll say, can X sue Y? And I say, almost always the answer to that question is yes. The better question is, should X sue Y, or can someone afford to do that? And so when you're charged with a crime like attempted murder, and you're facing the combined power of the government, it's incredibly difficult. So we were trying to do it basically with the two of us. We brought one secretary down with us, to the trial. But for the 2 years beforehand that the case was progressing, we were trying to do it on our own, and I was teaching at the law school full time.
One thing I should add is that this is a case of be careful what you wish for. I filed a motion for a change of venue, which I still have.
Times Union articles in
A lot
that
of
one.
And, and the fact is that there were a lot of really interesting things that occurred jurisdictionally, and because Peter was a beloved figure up here, and he was working for the presiding justice of the appellate division. So all of the judges from this area had disqualified themselves. So we didn't have an appellate division. Normally, if we need to get some outside help in a case, we run to the appellate division, which is on, downtown Albany on State Street. But here, we were dealing with, the appellate division disqualified itself, so we had to deal with the appellate division second department, which is in Brooklyn. So just the geographic problems that arose almost instantaneously.
Didn't Judge Berry get assigned first before the change of venue?
Yeah, Judge Berry was actually, he's a good judge. I don't agree with all of his rulings in this case, but he's a good judge and he's a good guy. He's retired now. And he was sort of the utility infielder among judges at the time. So they said, you, go to Albany County, take this case over, and he did. Yeah. And after he came in and the case got indicted and it started up, one of the things we did was file this motion for a change of venue, and it was granted. But then, of course, we found ourselves operating out of a motel room in Orange County. And
so Terry's law office is about 150 steps from the Albany County Courthouse. And I remember him scolding me once, saying, thanks to you, every week now I have to pack up these boxes and move to a hotel in Goshen. Somewhat.
Yeah, and there were some real difficult personal things that were happening. We had 2 teenage boys at the time, and they took a lot of abuse because of their parents. My house got egged, of all things. My car got keyed. Every time my kid Jake drove his car, the police would pull him over just because he was chargeable with driving while kindling.
And keep in mind, Terry lives in Bethlehem, so he's in the hometown where the homicide takes place. So
there were some real difficulties, and we were literally living out of a suitcase and a laptop and a little portable printer, and we had brought one secretary with us there, but we were coming into the courtroom, and the state of New York was represented by 2 extraordinarily talented prosecutors, supplemented by 2 equally talented prosecutors from an outfit called the New York State Prosecutors Training Institute, NIPT. And one of those 2 was a computer whiz. So, it's like, the New York Giants are going to play the Bethlehem Central High School. I mean, there's an imbalance here, so. Point.
So let's go back to the scene of the crime. So, and I'm doing this from memory, but it was a while. But I remembered, it's the middle of the night. You go into their house and you go up the stairs, and you have Jonathan's room to the right, and then you make a left, and there's another bedroom, a guest bedroom straight ahead, and then you go down the hallway to your right, and there's Christopher's bedroom and the Porco's bedroom was at the end of the hallway. And Peter sleeps on, I believe, the left side of the bed as you face it, or the right, oh, he's on the right side as you face it. And he has a sleep apnea machine, which has the white noise effect. And Joan would testify later that she is a deep sleeper. She never hears the dog, she never wakes up, she doesn't hear noises. Usually that's what Peter does. And so a screen on the garage, I believe, is cut. The house is entered, but it's unclear. Later it would come out there's some keys in different places. Like any family might hide them in a flower pot or, God forbid, under a mat because no one looks there. And the alarm is disabled, okay, which would later leave a fingerprint, a digital fingerprint of the deactivation of that alarm. And their aged dog, Barrister, which is the second dog I think they had named Barrister, is then put into the basement. And that became, and I know in some of the questions that were sent our way, people ask about that dog, and you made the point in your questions, which anybody might ask, is what burglar, what homicidal maniac would take time to put the golden retriever in the basement, or rather than just let him go out the front door or injure him. But the thing about this case is that if you, the prosecution's case is that Christopher parks his yellow Jeep in the driveway and for several hours does this, executes this crime. And as Terry noted in some of his legal arguments, it was a bloodbath. This was an axe attack, a horrific attack, vicious. So how did the college student get back in his Jeep, drive to Rochester, and not leave a single trace of forensic evidence, right? There was no forensic evidence as part of this case, and none. And so, Terry, that became, I think, a heart of your defense, didn't it, at points that...
Absolutely. I was allowed in the house maybe 3 days after the homicide, and it was a horrible scene. It was a bloodbath. There was blood literally everywhere in the house. Peter Porco, obviously, you could tell, had walked from his master bedroom down the hall into a bathroom. Clearly, he had looked in the mirror, bled into the sink, little half bath off the bedroom, then out the hallway, down the stairs, into the kitchen. And, his brain was obviously spinning because he did things that he must have done every morning. He started to make his lunch. He went to get the newspaper. I mean, clearly you could put this together readily by looking at it. And then he passed away, and there was just blood everywhere. So the state police, because they're statewide, one of the things that they did instantaneously was in Rochester, New York, they seized Christopher's Jeep. And the Jeep was placed on a flatbed truck, and it was driven down to Albany, and the state police took custody of it, retained custody for quite some period of time, and they took it apart down to the last lock washer. Plus, they planted a tracking device in it, which we found, but that's another story for another day. But anyway, and there was not a molecule, not a single cell of blood in there. And I'm sorry, but and I think this is dispositive. And if I was on Law and Order, I would have won this case, because the fact of the matter is that it is virtually impossible for a person to have engaged in the horrific acts of homicide and assault that clearly occurred in that house and to leave there without being coated with blood. I'm sorry, it can't happen.
And the Jeep wasn't cleaned, trust me.
I'll walk you.
We have 7 children. The Jeep looked like one of our teenagers had it. I mean, there was trash, there was, half drunk, coffee things, there were McDonald's wrappers on the floor. I mean, it was not a neat and clean Jeep. And they took and inventoried literally every scrap of paper. They took apart the Jeep to see, and used their very expensive, technology and forensics to, shine lights to see whether or not blood had been cleaned up, and there literally was not one drop of blood.
And there's no evidence in the dwelling of any blood having been cleaned off of a person in that place. So,
Right, and the theory seemed to be that, well, he could have gotten scrubs when he worked at the Bethlehem vet, and then he took off the scrubs, which were never found, and there were no scrubs anywhere, but maybe all of the blood got on the scrubs, and then they
And I
were done.
remember, that was during the defense portion of the case. You had put John Carney on the stand. John was the Bethlehem veterinarian who Christopher worked for his office.
Right.
And they were very supportive of Christopher, outspoken support. And he took the stand and talked about what a wonderful kid this is. And even though, the state police had kind of said, hey, he stole from you, we traced these stolen goods. In fact, one of your stolen cameras from your business we found in the safe in his room or something. And so, but when Carney was on the stand, I remembered seeing the jurors' faces, and I thought it resonated with them because it was you. Was it your cross or Mike? It was you. Mike started asking them. He started asking John about his safety and sanitizing and the training that Christopher had undergone to not transfer or be exposed to bloodborne pathogens. And suddenly you could see this theory of the case of the prosecution emerge through the testimony of one of Christopher's supporters, which I thought was pretty fascinating. Do you remember that, Mike? Did you think
No,
that?
I do, and the absence of the forensic evidence in the Jeep or any blood on his clothing was definitely a problem. I mean, that was something that concerned us from the beginning, that we didn't have a good explanation for, other than getting the jury to understand that the crime scene as it existed when Christopher was there is not the crime scene that the state police encountered when they got there, okay? Because most of the blood that you see throughout the house, or all of the blood that you see throughout the house, was Peter moving from the bed where he was attacked downstairs through the hallway into the kitchen, into the parlor. Chris was long gone by the time that happened. When Chris was there, he was swinging an axe over a bed with two sleeping people, okay? And we had experts testify about how much blood would necessarily result from this, and the cast off from the axe. And so when you went through that, the actual crime itself didn't create all this blood. The blood was from two people bleeding for hours and hours and moving around and touching things and falling into things. So it's not a bloody crime scene that he had to navigate. It's very possible he didn't get any blood on him. So when you take that fact, coupled with the fact that perhaps he learned how to clean up, perhaps he had some protective garments that he brought with him that he threw out the window of his car, who knows? I don't think that was ultimately something that the jury spent a lot of time worrying about.
But that was another, I thought, misstep. My recollection is that the Bethlehem Police, I thought it was trash day, and the dumpsters, though, they did not go up and down the street checking all the dumpsters.
Yeah, I mean,
If it
there
was
were a
done-
lot of things that
Yeah.
could have been done, should have been done in hindsight, that, potential avenues of investigation were lost.
but I don't think we prove cases by demonstrating what could have been done and wasn't done. I mean, we've got this system of justice here where they have to prove you guilty, you don't have to prove yourself innocent.
Well,
At least that's what I've always heard.
that's where the code to the master alarm came in, and the videos
Can
and all that.
Can I say one other thing about the blood? As Mike said, we believed, based on what the expert said, we had a blood spatter expert we believe we knew where Christopher was standing when he was swinging the axe. We could tell that from the horrible injuries on both of the victims, the angle of the axe. We knew that the perpetrator was standing facing at the foot of the bed on the left side, swinging in this area. Most of the blood was away from that area, based on what this blood spatter expert said. Also, so we knew where the perpetrator was standing. Right next to that, where that perpetrator was standing, is a chair. When you look at photos of that chair, there's not a drop of blood on that chair. So if the chair could be there during this attack and not get any blood on it, the perpetrator could be there during this attack and not get any blood on him.
Let's talk about what else was in that room. There was a watch. Peter's watch was on the bedside table next to the bed. There was DNA on the underside of the watch that was of an unknown person, but it wasn't Christopher. But basically, the response was, well, then it didn't have anything to do with this. There was a fingerprint. The telephone wires were cut in this case. Now, if the government's theory, which was that this was Christopher's home, he knew how to get in, he had a key, he had, the code, and so he could come in and he knew where his parents' bedroom was, wouldn't need to cut the telephone wires. But somebody cut,
Oh, it's in the backyard
right, somebody cut the telephone wires.
between them and the next house.
Right, and there was a fingerprint there. And so they found the fingerprints of everyone who had any reason to be there, the Verizon people, Christopher, Peter, Joan. If it had been Chris's fingerprint, believe me, that would have been, like the most important fingerprint in America. Because it didn't match Christopher and it didn't match the theory that the government and the police had, that was just considered to be not important at all. And we got a call from a local funeral home, and the guy who was the owner said, I drove home at night. There's never anybody there. There was a car that was speeding away from Broccoli Drive. And the next morning, I heard about this horrible murder of my neighbor. So I went to the Bethlehem Police to tell them about this car. And the Bethlehem Police said, oh, don't worry about that. We already know who did it. It doesn't matter who, was driving away in the car. And that just happened over and over and over. 2 years were spent finding out whether or not Christopher, and I mean, believe me, we certainly came to the conclusion that Christopher had done some really not nice things in terms of taking money, in terms of being, sort of a flaky kid, in terms of over, drawing his account. But literally 2 years were spent trying to find every bad thing Christopher had ever done in his entire life. Not one of those things had anything to do with violence. And that, in my mind, just the story doesn't make sense. Both Terry and I, between the two of us, and he's older than I am, but not by much. We have about 100 years of criminal defense experience between us. People don't wake up in the morning and suddenly become violent just because they overdraw their checking account. And basically Mike did tell Joan Porco that he knew her son better than she did. And all I can say is, as a mom, I never was convinced that Mike McDermott knew her son better than Joan did. And we were just in a position, I'll let Terry talk about, the nod and our expert witness, but, that's sort of what I've never been able to reconcile, no matter how many years this has gone on.
But I remember with Joan when she testified too, that was heart-wrenching, of course, and she had given her grand jury testimony at Sunnyview, where she was in rehab and just went through terrible surgeries, difficult surgeries to rebuild her parts of her skull, her jaw, and help her eat, all these different things. And I remember, though, that on the stand, she was lucid. She remembered things well, and I think, Mike, that was your cross. And on redirect, you asked her about the 2002 break-in. And that, hey, it was on Thanksgiving. He stole your laptop, and she corrected you and said he didn't break in. He lived there, and it's unfortunate that he didn't tell me his needs. So she wasn't willing to certainly throw him under the bus for that, and seemed to do everything she could, to still want to protect her son, believe in her son, through to the end. And that when you juxtapose that against Jonathan, when Christopher's brother testified, that was a different dynamic completely. And Lori, when you were doing the cross of Jonathan, And I remember as he came into the courtroom, he's a naval officer. To my knowledge, he hasn't spoken to anyone about this case today, not publicly. And Jonathan would not make eye contact with his brother. Other witnesses had, and when he came in, he wouldn't look at him. And you being the veteran lawyer you are, you did most of your cross standing behind Christopher with your hands on his shoulders. I felt like you were trying to get Jonathan to look at his brother, but maybe.
It was, I don't remember that, but I just remember that Joan was so devastated, because these are her two sons. And when you say that she was lucid and she remembered, she certainly remembered things, but not about the attack. And in fact, Mary Dom Bovie, who is a
Doctor.
Certified neurologist, said that it was absolutely impossible, given her injuries, for her to have formed a memory, and that because of retrograde amnesia, there's no way that she could have done it, and that basically the nod was meaningless. That she has people. She runs a rehab in, was it Rochester?
Rochester, yeah.
In Rochester, and she said that police come in to ask her about interviewing people, and she said that the interview that the Bethlehem Police Department did was meaningless. That you would have to establish that she knew who she was, that she could acknowledge that there were questions, and she said that certainly someone who is devastatingly hurt may respond to the names of loved ones, but that the questioning, or the idea that she was answering, was in her mind meaningless. Obviously, it was the most important fact in the entire trial, and in fact, it was clear that once the police heard that, once Paul Klein heard that, once the prosecutors heard that, there was never a serious never a serious intent to look at anybody else. It was just 2 years of, we're going to prove this guy is a terrible person and that he could have done this, because you can't prove that he wasn't at the house, and we can prove that he wasn't at the dorm, and therefore he must have done it.
This is going to get us to the nod, which is clearly the most significant legal issue and the most significant factual issue in the case, but I'll wait until the time is right.
Yeah, and I just want to chime in just
Go ahead,
a little
Mike,
bit on this.
please.
Because, the head nod is obviously the piece of evidence that came out first, that grabbed the public attention, that, kind of is the center of fascination. But we tried to build a completely separate case that had nothing to do with the head nod, based on, verifiable evidence, so that at the end of the day, the jury could do what they want with the head nod. We had experts saying that it's possible, she knew what she was saying, that, the defense expert was wrong because by the time the experts actually got to evaluate her, she had all these surgeries, she had all kinds of narcotic drugs as far as, her memory goes. But that was besides the point. The head nod, whether Joan was lucid and actually knew who attacked her or not, she put the police on to Christopher, and then every angle that we looked at about Christopher pointed to him being the assailant. So when the time came for the trial, the head nod was part of the trial, but it was only a small part of the trial. And at the end of the day, the jury even said that they discarded the proof on the head nod. I mean, I think the proof that I think was much more persuasive was the videos regarding his Jeep, right? When he said that, he had parked his Jeep and then went and slept in the lounge in the dormitory, and then after reviewing hundreds and hundreds and hundreds of hours of video cameras from all over the city of Rochester, you were able to see his Jeep leave campus, drive to the thruway.
At 10:30 p.m. it left.
And then the next morning, that same Jeep come right back the same way to go and park at the school parking lot. And the Jeep was, not only was it a yellow Jeep, so it's kind of distinctive, but we had forensic video examiners. You couldn't read the license plate, but you could see all of the decals, you could see all the mud stains. I mean, it was beyond a reasonable doubt the same Jeep, okay? That's the kind of proof I think that convicted him. It wasn't Joan's head nod, even though that was the most, notorious piece of evidence, but it was that actual hard physical proof, I think, that at the end of the day, the jury based their decision on.
Okay. Now, I very respectfully beg to differ. And Exhibit A, Mike McDermott's closing argument. This head nod don't mean nothing, right? Well, if that were the case, then why is it that he brought it up? I counted them 12 times during the closing argument. Why did he bring it up during the opening statement? And I submit that it's because it is so incredibly persuasive as a piece of evidence is concerned. Now, there's also a fascinating and I think fundamental legal issue that goes with this. Can I talk about that now?
Sure.
Okay, all right. So,
Remember, though, we're not at the law school, so don't
no, okay.
go on too long.
There was actually a betting pool when this case went to the Court of Appeals, the highest court in New York State. There was actually a betting pool among lawyers who work downtown, I found out later on, that some people were picking there was going to be a reversal, and some people were picking there was going to be, that the conviction was going to be upheld. There was money in a hat someplace to deal with this. And that is because there is in the center of this case, the absolute nucleus of this case, I submit, is the head nod. And here's the legal issue. Joan allegedly, and we've never accepted this, but Joan allegedly responded to a detective who said to her, in sum and substance, "Did Christopher do this to you?" Now imagine this poor woman is lying broken in her bed, her skull literally split open, her jaw hanging loose. I mean, she was in terrible shape. How she ever survived it is a mystery. But supposedly, she said, she responded by shaking her head and moving her finger. Now, I've been speaking English for 73 years, and I don't ever remember learning that this means yes. I don't know what the hell this means. But she supposedly answered in the affirmative, and that's the way the story was laid down, and that's the way it was spun from that point forward. Every single chance they got, including 10, 12 times during the closing statement. And of all people, and this case had something for everybody, because of all people, it was almost Antonin Scalia to the rescue, of all people, in a criminal case. So Antonin Scalia made a decision in this case that came out while we were getting ready to go to trial, called Crawford against Washington. And in that case, there was a witness who, in response to a question from a police officer, gave an answer that was helpful to the prosecution. Like our case, where a witness, a supposed witness, gave an answer to a police officer in response to a question that was helpful to the government. How am I doing? Okay?
But then has no recollection of that, right?
Well, that's the good part. So
Okay.
in the Crawford case, it was out of Washington State, and in the Crawford case, the woman was alive and well, but she could not testify at trial because in that state, the marital privilege, and the testimony would have been offered against her husband, the marital privilege was so strong that she simply wasn't allowed to give this testimony. And the judge said, that's ridiculous. You know, Officer McGillicuddy, what did she say? And McGillicuddy testifies, this is what she said. It was inculpatory. The guy was convicted. So off the case went, eventually got to the Supreme Court. So in our case, setting aside the question of whether Joan was capable of recording this information and storing it and remembering it, in our case, clearly, when trial came along, she had no recollection whatsoever of the events at issue, none. So what that meant to us as defense lawyers was we couldn't cross-examine her. How can you cross-examine somebody about something that they don't know? And as I said as respectfully as I could to the 3 appellate courts that I went to, it's like trying to cross-examine a chair that was in the room. It's meaningless waste of effort and time. And that kind of testimony is called in the law school, it's called testimonial hearsay. And that's a specific answer given to a direct question by a police officer interviewing a witness. The witness subsequently becomes unavailable. Well, the Appellate Division Second Department, where we argued the case down in Brooklyn, the Appellate Division Second Department said, yeah, it is testimonial hearsay. But then they went on to say, but we don't really care, that there was overwhelming proof. So it's even though it was a mistake at trial, it's not a fatal mistake. And I really had high hopes that the Court of Appeals would say, concerning our testimonial hearsay, that evidence should not have been received. And what the Court of Appeals said is that whether it's testimonial hearsay or not, we don't care. That's showbiz.
The rest of the case is strong.
The rest of the case is so strong that you lose. And of course, and I won't go off into the legal weeds here, because there's a lot of good arguments that I could sit up here and make to myself for the next 3 hours. But suffice it to say that we felt that was a compelling legal issue. And after the highest court in New York is called the Court of Appeals. So after the Court of Appeals affirmed the conviction, we filed a petition for certiorari with the U.S. Supreme Court, where the Crawford case had been decided. And for the next 6 or 7 months after we filed the petition for a writ, I really thought it was going to be granted. It was looking good. But then, because of some things that happened in Washington, they ultimately said no. So that nod is, and I guess it's probably at this point, it's like, pick your favorite color. But the fact of the matter is that we think that the nod was conclusive evidence in the minds of most of the jurors, and that if it had not been for that the case would have been exclusively circumstantial. And under those circumstances, or in that case, I should say, we felt that there was enough reasonable doubt that a fair-minded jury would have acquitted.
It was considered, I guess, the only direct evidence, is what
Yes.
you would call that statement. So Dave, you respond, I know you.
Yeah, I won't
And
disagree.
then we're gonna move on from the nod a little bit.
I won't disagree that it was a very complex legal issue. In fact, we built the case assuming we were not going to get the head nod in. So we really were kind of surprised. We made the arguments and it worked with the help of the NIPD. But we built the case assuming we were not going to get the head nod in. I think the reason it kept getting mentioned by Mike during his closing is because the defense in this case were doing their jobs, but it was a constant attack on the investigation. And so to explain why are we focused on Chris, well, we're focused on Chris because of this head nod. That's what sent them in that direction. That's why Mike was mentioning it a lot. But I think we need to be a little more specific about what the head nod was. It wasn't just, hey, Joan, did Chris do this to you? And she nodded her head. It was much different than that. Joan was being treated on the bed by the paramedics, and they said that she appeared to be lucid. They said that as they dragged her across the bed, her underwear was exposed, and she was pulling her shirt down to cover herself. And that has some meaning. And so they asked her, as Detective Bowdish snapped a couple of pictures, and he said, give me the names of the 2 kids who live here. So he came back up. He said, can I ask her some questions while you wait for medication? Yes, you can. Do you know who did this to you? And she nodded her head, and she was making hand motions. Joan was a speech pathologist. She was making hand motions as well as nodding her head. Was it Jonathan who did this to you? And she shook her head back and forth and waved her finger back and forth. Was it Christopher that did this to you? And she nodded her head again. So it wasn't just, I never put a lot of weight into that in the beginning, honestly.
Let me just say, there were 4 people who testified. Only one of them said it that way.
Well,
One person said she was yelling and she was moving around. Another person said she wasn't doing anything and was laying quietly. So the idea that she was rational and was making these hand gestures and that everybody agreed who was in the room that that's how it happened was not the testimony.
And that's why I needed to cross-examine her, like a lawyer does. We do this cross-examination thing. It's supposed to be the greatest engine for the discovery of truth in Western civilization.
Not that we feel strongly or anything.
All right, Dave, finish your point.
No, and my point was, I guess I will take exception with that as well. The detective and independent paramedics who had no axe to grind, who had no other. That really was not intentional. That there were independent paramedics who said that's what happened.
All right, so the thing that fascinated me at the trial down in Goshen, a little courthouse with not a really big park. Most people parked behind the courthouse. Everyone, all of us, the prosecutors, the news people, the observers, the jurors, the court officers. And so after the state police searched and took Christopher's Jeep apart, he was out on bail for quite some time out, and they gave it back to him. And, we used to get calls from people. That yellow Jeep is parked on Lark Street in front of a bar. I'm like, what do you want me to do? It's like they call us about Keith Raniere of Nixie and say, he's out for a walk. Okay. But during the trial, the Jeep became such a focal point. And Terry, I was always shocked. I feel to this day that if Chris drove a gray Toyota Camry, he might not be in prison right now. But he parked the Jeep at the courthouse. And I saw jurors walking by to their cars and looking at it. And at one point during the trial, Terry described it as a jukebox on wheels, because it wasn't just a Jeep, it had a lot of extras. And that was what led the toll collector, what are the odds that the toll collector remembers that Jeep because he's a Jeep aficionado? There were some circumstances in this case you couldn't make up. If you put it on a Lifetime movie, they'd say this has got to be a Lifetime movie. So, but in hindsight, Terry, having that Jeep in the parking lot every day, you think not a good decision?
Brendan, I've been making stupid mistakes as a lawyer for almost 50 years now.
I'm sorry.
And I am sure that over the next 50 years I won't make anywhere near as many. So I'm hoping for the best.
Yeah.
But it's interesting because one day when this person will remain nameless, but I walked into the courthouse and a deputy said to me, I need to talk to you. I said, okay. And he said, you can never say, that I told you that, giving his name, which I'm not going to. And he said, I just want you to know that I live near Broccoli and I have a yellow Jeep. And he said, no one's ever asked me. He said, it's parked in my driveway and the police come by, but they weren't interested in any other yellow Jeeps.
Jeeps of this construction, what is it, a Wrangler? A Wrangler, whatever it is. It's okay. But I think they're all yellow. There might be a red one out there someplace, but it isn't like this is a unique vehicle that exists only in the pages of some hot rod magazine.
But certainly, on the cameras at the college, seeing those images of it leaving, I think it was devastating. The effect on the jury to see it.
There was also a day, I don't know if you all remember this, but a day where the judge called us into chambers before we started, and he said that, I believe it was one of the court officers said that Chris came whizzing into the parking lot and almost hit the jury in his Jeep and asked you to have a conversation with him about maybe not being so reckless in the parking lot.
I don't remember that.
But
sorry.
Anyway, but that, so one of the things that also fascinated, I think, our readers and the public in general about this case was that first of all, it took a long time to get to adjudication because of the pretrial fights that went on and the change of venues. And I remember Judge Berry coming up in the middle of winter nights, I think it was, to hear some of the arguments in the courthouse.
Yeah, he came in at 9:30 one night.
Yeah, at night, because he had to travel so far from Orange County to get there. But there started to emerge other theories, and the state police were chasing some of them, and you couldn't make this up for a lifetime, that Peter Porco, the soft-spoken, kind-hearted, wonderful, and beloved law clerk, has a great uncle who is a boss in the Bonanno crime family. And Frank Porco, when Joan first met Frank, they went there to get their wedding ring for her. And that was the first time she met him down in Brooklyn or wherever. And then he comes to their wedding, and he's apparently a mountain of a man and very intimidating, dressed flashy with flashy jewelry, to the point people up here in Bethlehem are like, who is this guy at the wedding? And crosses his leg, and he's got a revolver strapped to his ankle.
Frankie the
So
fireman.
there
He had a
started
nickname, too.
this undercurrent, this rumor of another theory and of a mysterious box of money or bag of money being in Peter Porco's closet, and that this was really a mob hit or a payback for something that his uncle did. And tell me a little bit about that.
The truth is out there. I know that we'll find it someday. You know, there was Frankie the fireman. That was Peter's relative. There was a lawyer in Troy, Richard Hanft. He's passed away now, but Richard called me one day and he told me this blood-curdling story. He said that some years before, there was this guy who was a respondent in a family court case at a time when Judge Cardona, Peter's boss on the appellate division, Judge Cardona was a family court judge, and Peter, as ever, was Judge Cardona's law clerk. And what had happened was there was this very bitter, nasty custody dispute in their court. And Peter was very much involved in it, and this guy, I can't remember his name, was involved, and he lost the case, and he was mad. He was mad as hell, and he made threats. And I think, and I can quote directly, my kids do this when they quote me. I'm going to get away with this. He says, "I'm going to get that guinea son of a bitch," is what I heard. And he worked for the railroad, we found out. And here's what happened. So Richard Hanft had been the lawyer for the mom who won the case. And he was at the YMCA in Troy one day, and he's walking around bare naked. He's just going swimming and taking a shower, and he's in the locker room. And you don't get much more vulnerable than this. And who comes by but that guy? And it scared the hell out of Richard. It really did. And I mean, and not without reason. And Richard discovered that this person worked for the railroad, lived in Virginia or North Carolina or someplace, but he traveled up and down the eastern seaboard, and that he was around. And we said, maybe he's the guy who did it. So we pursued that as far as we could, but we don't have troopers in every county.
Was this because of Peter's work as a law guardian?
Because of Peter's work as a law guardian, yeah.
So he would represent families of, the father who just found out that his daughter is getting shipped to the wife and her new husband in Florida, and these people would lob death threats against Peter. And so for a time, in his Bethlehem home, he kept a shotgun next to his bed. And they were in fear. I mean, Joan testified that
Joan had told us that they had security at their house, like lights that go on when you come close, and that twice in the month or so before Peter was murdered, there was a strange guy in their driveway. And again, this goes back to she tells us this. Well, what are we going to do? Call the Bethlehem Police and say, we think that there's somebody who, you've made a mistake. And Dave is right. We did hammer on the investigation because we firmly believed then and now
it was a phony investigation.
That they didn't investigate the crime. They investigated Christopher. So, I mean, we had thousands of pages of his bank statements, where he would get a $35, fee because he bought a bagel for $4.20 and he only had $3.18 in his checking account. And so we would have thousands of pages of those, but we didn't have anything about the car that was screaming away from Broccoli Drive.
Right. We should talk about that briefly. There was a guy who ran a funeral home, which is a block away. You've already touched against it, but he apparently his business could have been better because he was also working as a luggage handler at the airport, which gave him strange hours. So he was coming home from work at like 4:30 or 5 o'clock in the morning, and that's when he saw two cars speeding away from Broccoli Drive, and then we hear about Frankie the fireman and a box of money. There's more to this than meets the eye.
So go ahead, Dave.
The individual from Virginia, his name was DeLuca. He is someone who had
Patrick DeLuca.
He had threatened Peter in the past. That was a lead that was followed up on. He was alibied using swipe cards the morning of the homicide.
Right,
as
by a bunch
being-
of prosecution witnesses, they alibied him. I mean, no disrespect
Well,
intended here.
Those are the only kind of witnesses we have.
I
but,
know, we've noticed that.
They were people that worked in Virginia, so I don't know why they would care. But anyway, he was alibied. The two cars fleeing the scene, it wasn't actually on Broccoli Drive, it was in the area. And we had a description of the car, and we did everything we could. I don't know what more you can do other than interview the person who said, I saw two cars driving fast.
But they
and
didn't
they were
interview
dark.
the person. They said, we don't need any more information from you because we know who did it.
It was
Right.
it was subsequently followed up on. Frankie the fireman, that theory is absurd. Frankie,
Right, there was no mafia.
Frankie was interviewed. Yes, he was in the mafia. He did not cooperate. That's why he was in a federal prison when they went to speak to him. And the idea that the Bonanno crime family sends a hitman up to Del Mar, New York, without a weapon and tells him to find an axe and take the axe from the garage and use that one, frankly, to me, is absurd. And again, we traced that as far as we could, and as we did with all the leads.
So there were two timelines that the prosecution built. One was a timeline, and I'll let you get to mitochondrial DNA in a little bit, but you got to promise me only 90 seconds, because I had to sit through that. But so they had a timeline of the Jeep coming to Albany and going back, and the theory of how he did it, hiding the easy pass, breaking through. But then there was this timeline that emerged.
Can I just say this about hiding the easy pass? I found that to be one of the most absurd. So what happened is that he has an easy pass, right? Which of course his parents are paying for. We're still paying for our kids' easy passes. And the theory, so they literally went through every one trying to find, his easy pass and where he had done this. And clearly they couldn't find it. So they had this theory. Oh, and they also went to every single gas station between Rochester and Albany on the assumption that he would have gone in and he would have bought gas because he had to buy gas. And they literally had tens of thousands of pages of his bank records. And we, having had children approximately the same age, said, kids don't carry cash. My children don't even know what a checkbook is. I've tried to explain that to them. And so this idea that somehow he had the wherewithal to wrap up the easy pass so that it wouldn't automatically go on, and that he had paid for gas without his credit cards, which his parents were paying for, with cash. There was no indication of where he would have gotten cash in order to do this. In fact, their theory of why he was going to kill his parents was to get money. The reality is that this is, again, the story doesn't make any sense, that his parents were giving him money. They were worth a lot more to him alive than they were dead, and I don't mean that with any disrespect. They were giving him money. Were they mad that he was doing things like, not getting good grades at school and lying about, his credit cards and stuff? Yes, but not a reason to maim them or to kill them. And everything that we knew about Christopher and that they found out about Christopher is that he wasn't a planner. So the idea that he made this master, brilliant plan just didn't make any sense.
So I'm going to let the prosecution counterpunch here a little bit with the timeline of his collapse in college. Academically, the first semester, he's not doing well. He told his parents he had mono. He's flunking all his classes. At the end of the first semester, they're going to have him removed, but a dean intervenes and meets with Joan Porco and her son and says, let's give him more time. We'll watch over him closely. Maybe this college experience, he'll get caught up. But it doesn't work out. He continues, I believe, to struggle greatly in college to the point where Dad is saying, we're not going to keep paying for this if this is what you're doing. She really wanted him to come home, be closer to home, to the nest. Maybe he'd do well in school that way. And then he goes to Hudson Valley and to attend classes there. And University of Rochester gets a transcript from Hudson Valley with these great grades on it, but who wants this? Dave or Mike? Tell me about, how you started to build a timeline of his collapse academically, leading to the fact that he's reached the point where he can't fool them anymore, I think was really your theory.
And Chris was a pretty sophisticated guy, right? I mean, he was able to commit these burglaries at his parents' house, at his employer's house, was able to market all these electronics over eBay to get a second source of money. There were other laptops that he was selling over eBay that had been reported stolen from the University of Rochester. He's able to fake a transcript from Hudson Valley to support his reentry to the University of Rochester. I mean, he's pretty sophisticated in the ways of deception. I mean, there's nothing about Christopher that is infantile or juvenile or can't figure out how to pay for gas or cover his tracks on his way home from committing a crime. And he knew that his parents were onto him. I mean, if you look at the stream of emails back and forth between Peter and Christopher leading up to the crime, Peter's no longer taking Christopher at his word. The kind of BS explanations that Chris would give about, letters coming from credit card companies or the loan for his Jeep or the tuition payments for the University of Rochester. It seems for a period of time, Mr. and Mrs. Porco were just kind of accepting whatever far-fetched explanation Chris gave, but in the weeks immediately preceding the homicide, Peter's starting to push back. Peter's starting to call the credit card companies himself. He's starting to talk to the bursar at the University of Rochester. He's starting to talk to the car loan places and realize that he has not been getting the straight scoop from his son. And worse yet, Christopher has been actually forging Peter's name on loan documents, using Peter's social security number to get loans, and Peter said, "This is it. You're done." I mean, there was even the comment that was made about whether or not Peter thought Christopher was a psychopath. So his house of cards was starting to crumble, and when you look through the chain of emails immediately preceding the homicide, you could see that this was building to a crescendo. Peter wanted Christopher to come home so there'd be like a reckoning, and Christopher kept putting it off. But I think it was clear to Christopher that this whole facade and all of his deceits had caught up with him, and that there was going to be some major changes in his life because his parents weren't going to put up with it anymore.
But there was also a lot of things Judge Barry seemed to, I don't know, it almost seemed to me, again, as just the observer there, that he wanted the prosecution to have enough, but not too much. I felt like in his rulings, they never saw the falsified transcript from Hudson Valley. They didn't see all of the break-in evidence. He gave you certain things. Again, I'm a layperson, but it seemed like he was giving you enough to build your case, but holding back enough so that he wouldn't get reversed on appeal.
Sure. Well, the thing is, so whether Chris sold stolen laptops on eBay, whether he forged his Hudson Valley transcript, whether he forged Peter's name, they don't prove the murder, right? I mean, these are circumstantial evidence. There are other crimes that kind of point in the direction, okay? So the judge, Judge Barry and most judges do not want to let too much of that evidence in, because you don't want the jury convicting somebody because they're a bad person and they're generally, prone to commit crime. You convict them because they committed the crime they're charged with, okay? But some of that information is important for the jury to know, and so the judge did a balancing act. He let some of the stuff in and some of the stuff he precluded.
But mitochondrial DNA, do you want to go on that door yet?
Thank you. Let me preface what I promise will be a very short discussion of mitochondrial DNA with a little story. This is a true story. I was asked, I'm a Vietnam vet, and was always very grateful to the government for putting me through college and law school after I got back from Vietnam. I always thought that they were terrific to me. So I always felt like, I owe the team something. So I got a call from this guy out in Delaware County, and he had been convicted of a pretty bad murder. And I got involved in the case and discovered that the that 3 senior investigators from the New York State Police, which I think the prosecutors want you to believe is sort of the equivalent of the Mormon Tabernacle Choir. 3 senior investigators from the New York State Police had, when my client, his name was John Spencer, when he was arrested, they had tricked him, very cynically tricked him into leaving his fingerprints on a piece of metal in their troop office in Sydney, New York, down in the middle of nowhere. And what they did was they took those fingerprints to the murder scene and they planted them there. Tampering with evidence. I mean, just massively fraudulent, evil. And the thing is, what really killed me is that they didn't need to. They had everything except a movie of this guy committing the crime. But they called it, framing the guilty. That's what they called it. It was a thing.
And it wasn't only in that case either, was it?
No, it was in several cases. All hell broke loose out there. 3 senior investigators went to state prison. And at the retrial, I had the supreme joy, got to stand up for this one, my legs asleep, of cross-examining. I had the supreme joy of cross-examining a senior investigator from the New York State Police who was in his prison uniform wearing chains being guarded by a corrections officer. It was heaven on earth for a criminal defense lawyer. So anyway, I come by my skepticism honestly, all right? Now, they want us to believe, and I guess we did, they wanted us to believe that they went through this trove, this vault of turned-in throughway toll tickets. Billions of them. And that, mirabile dictu, as Brother Conrad used to say to me in high school.
And this is before Easy Pass is really that popular.
Right,
so most people are still paying cash in 2004, and that ticket you take, and there's nothing linking it to the driver, the motorist. Right.
So what they did was they got all the tickets from Rochester to Albany, and then, according to their testimony, they found on one of the tickets this sort of subspecies of DNA. Now, DNA is considered, and rightly so, to be one of the most powerful forms of identification evidence available in the criminal justice system. But again, we're talking 18 years ago, and we've come a long way since then. But here's the deal. The DNA that we're all familiar with from TV and from, all the different discussions of it that have reached the public is what they call nuclear DNA. That's the good stuff, okay? Now, go back to high school biology for a moment and think of a cell. Just imagine this cell. You remember it from high school, big sort of oblong thing. And in the middle is the nucleus. But around that is the mitochondria. And there is DNA in that mitochondria, but it just isn't the same. It is nowhere near as reliable. I mean, you go to court these days in a case involving DNA, and the expert will come in from the state police lab and say, well, I can't say it's his DNA, but I can tell you this, that if you looked at 3,642,000,000 people, he'd be the only person who qualified for that being his DNA. That's the way it's just sort of sounds like Jeopardy. They turn it upside down and backwards. So, but this mitochondrial DNA is not the good stuff. And I spent a lot of time out at Syracuse University with a guy out there. I got to hand it to Mike. He killed my client on cross-examination. Learning about mitochondrial DNA. And he certainly convinced me that this DNA was just not that reliable, that it didn't really indicate reliably that it was placed there by Christopher. That's if you assume that they had really found some DNA to begin with. And based on my prior experience in the Trout Creek case, the Sydney, New York case, I was very skeptical.
But you guys take this, but let me set it up for you. So the reason they were able to narrow the number of cards was because I believe they were cataloged, right? The way they were inventoried. So go ahead and explain.
We were actually really surprised to learn. We learned a lot about the throughway during this because there's so much money. I couldn't believe the amount of money that runs through those booths every day. And fraud and theft. They have a really specific way they do things. First of all, they all wear gloves. They hit a button. It's in a box, in a sealed box. They feed it up into a feeder. When you drive through, they hit a button, the ticket pops out, they take it with their gloves, they hand it to the driver. The driver does whatever they do with it until they get back on the other end. They take the ticket and they drop it through a slot and it goes into a box. So there's really not a whole lot of people putting hands on this that aren't wearing gloves other than the motorist. And then they take these boxes and they keep every single one of them in a warehouse, every one of these tickets. So when the state police went and they said, let's collect all the tickets going from Rochester to Albany, Albany to Rochester during the relevant hours, and there was just a handful, really. And so the first thing the state police did was they tried to get fingerprints off of them, and there was really nothing of any value. And then they said, well, let's submit it to the lab, see if we can get DNA off of these, couple of specific tickets. And they got some DNA, but it was not enough for them to do anything with. And that was a dead end for the toll tickets. And we were like, okay, that we struck out there. Months go by, and I remember sitting down with Mike, and Mike saying, Dave, is there anything else we can do with that DNA from that ticket? Months had gone by. And then we started looking into it, and we found this lab in Pennsylvania that does mitochondrial DNA. So we learned about mitochondrial DNA. We said, let's give it a shot. So the people at the lab in the biosciences section, we had them mail it down to this lab in Pennsylvania. They analyzed the toll ticket, and they said, we got a mitochondrial profile off of it. It's not as discriminating as nuclear DNA, that's true. They said, but there's this weird little something in it that 99.6% of the population doesn't have this one little thing, but it's kind of interesting DNA. Send us Chris's DNA. So we sent Chris's DNA, and guess what? Chris happens to be within that 0.4% of the population that would have this strange thing. So is it nuclear DNA? No, it's not, but it's just another piece of the puzzle. And again, it didn't come about by senior investigators, and that's a horror story, and they belong in prison, what you just told there. But this was biosciences people at the lab who sent this off at Mike's request, really.
0.4 of the population, 0.4 of the population of the United States is probably a couple 100,000 people, right?
Yeah, I mean, listen, the mitochondrial, the probative value of the mitochondrial DNA wasn't that great, okay, but it was there, and it added to the mountain of other evidence. And the thing was, they didn't look through thousands of throughway tickets because we knew from the video showing the car coming back from the throughway, we knew to say, look in this very short period of time of cars coming from Albany to Rochester. And we knew from the video from the night before showing the Jeep going to the Thruway Plaza within a very short window of time, look only for those cars. So there was only a small number of tickets that needed to be sampled. And the mitochondrial DNA, back 15 years ago, I mean, that was not tested by the state police. They did not have the equipment to do it. They didn't have the personnel to do the analysis. That was the kind of DNA that you see, like when they find bones that are, thousands of years old, and they use it to do maternal testing. Okay. Since then, it's become much more popular and much more sophisticated, and it's used much more often. But again, it's not nuclear DNA. Nobody ever tried to persuade the jury that it was nuclear DNA, but it's a small piece of the puzzle that fits with all the other pieces of the puzzle.
And when we argued this case in the highest court, Judge Smith looked at me and he said, but counsel, they had DNA. And I wanted to say, well, you got 45 minutes, we can talk about it. But you can't do that. So.
Why does Christopher not testify? Is it because of the other evidence that you already knew was going to be out might come in then?
Okay, on my gravestone, it's going to say, why didn't Christopher testify? I know this for a fact. There was a statement given by Christopher, as we've previously discussed here, that was taken by the police over about a 6.5 hour, 7 hour period and video recorded. They used that statement, and I don't know what the legal argument is that I'm looking for here. I've never quite been able to figure it out, but they used the statement that he gave to prove that he couldn't have done these things. That was the way that they put their case together. It was a very destructive approach. And of course, we had this imbalance of resources and so forth and so on. The statement had been suppressed by Judge Berry. It had been excluded from use at the trial. The DA was deprived of the ability to use that statement. So they were going to tell this story during the prosecution part of the case. That's the front part, the beginning, the first half of the case. And we had, there's an old lawyer joke from New York City. Somebody says to the lawyer from Manhattan, "What do you charge to represent somebody in a criminal case?" And he says, $100 grand. $100,000, that's a lot of money. He says, "Well, I charged $5,000 for doing the case and $95,000 for figuring out whether to put my client on the stand or not." And point's well taken, because you don't really know. And and Lori and I happen to feel very strongly that it is infinitely preferable to put your client on the stand, because the jury should hear from your client. And there's hardly a case that we've ever tried where we don't put our client on the stand. However, Chris Porco, we felt that it would not be the wisest thing to do, because, imagine this, we've just spent 4 weeks, 5 weeks hearing the police putting in all this evidence that essentially unravels the explanation that he gave in the police station on the night he was taken into whatever it was, custody or not custody. So the statement's out. They can't use the statement unless we put him on the stand. And if I said, "Hi, Chris, what's your favorite flavor?" and he says vanilla, I said, "Thank you, no more questions." And he sits down, the whole statement comes in. So we would then have spent the next 4 weeks running through his statement a second time. And it was a painful decision to make, believe me. And maybe when I die and go to heaven, God will say to me, "Kinlan, you really screwed up here. You should have put him on the stand." I don't know, but we felt very strongly that it would be against our client's best interest to have him testify, because it would have opened the door. Once the statement has been suppressed, it's out, unless the client takes the stand to testify. Then the door opens wide. And it would have then given the prosecution the opportunity to run the whole case again a second time.
The other thing is that, Brendan, you're right. The judge sort of tried to, well, I'll give this side some and I'll give this side some. And part of the problem, and lawyers say all the time, hard cases make bad law. And if there was any case to demonstrate that, it's this case. It was a very emotional case. It was emotional for everyone. Peter was our friend. Joan became a very close friend of mine, over the course of this. And, Chris had done things, like, falsifying his transcript, taking laptops. I mean, he had done things that were not good. And one of the things that we always know is that if your client takes the stand, the jury's going to decide, do they like your client or do they not like your client? And there were certainly reasons why someone would not like Chris. I don't think they had anything to do with Chris being violent. Literally, there was nothing in Chris's background, nothing in their family dynamic, nothing that would indicate that he had ever done anything violent or would do anything violent. But, would Mike be able to cross-examine him on, the laptop and on the transcripts and on the emails and those sorts of things? Absolutely. And it would have been devastating. And as Terry said, I mean, one of the things that was so angering to us as lawyers is that Paul Klein made a decision, to not allow the lawyer who was there. If John Polster had gotten into the room, he would have told Chris not to speak, as any lawyer would have. And basically, in my mind, the prosecution was rewarded by intentionally ignoring the Constitution. And allowing someone, a child, essentially a young adult, to be interrogated for 6 or 7 hours while his lawyer was prohibited from coming into the room. And they then used that tape. And Davis Wright, he certainly told other people different parts of the story. So, it's possible that they could have gotten in some of that evidence anyway. But in my mind, they were rewarded for intentionally flouting the Constitution.
And at all times, it's critical to remember here that Judge Berry, who held a magnifying glass over the facts and the law in this case, suppressed the statement. He excluded it. And that is so extraordinary as to be close to unbelievable in the day-to-day work of the criminal trial courts in upstate New York.
I think anybody who thinks it was a mistake to not put Chris on the stand doesn't know the case well enough, because we were chomping at the bit for Chris to be on the stand. Mike, I know what Mike would have done to him if he had. But there was one part of the interrogation that I thought was some of the most damning evidence that the jury never heard. And it was this: while Chris was being interviewed, he was asked by the police, any reason that your mom and dad would have turned off the alarm? And this was before the police got into the alarm system and knew what had happened with the alarm system. But they knew there was an alarm, and it was smashed. The panel was smashed on the wall, and they said, "Tell us about this alarm. Any reason it would be turned off at night?" And Chris goes, "Yeah, a lot of times the dog Barrister will get up and have to go outside between like 2 or 3 in the morning, and my dad will let him out and then forget to reset the alarm." Oh, okay. We move on. The next day, they get into the computer system of the alarm because it's saved in the basement. It's not in the panel that was smashed. And lo and behold, they see that the master code was punched into the alarm system at 2:15, I think, in the morning. So now you might say, well, that corroborates what Chris said. They must have let the dog out. The problem with that is, when Joan was interviewed and asked, does Barrister ever go out in the middle of the night? No. And when we went and looked at the history of the alarm system, it only went back 15 days. But in 15 days, not once did that dog or did anybody disarm that alarm in the middle of the night. And
That's not true.
Well,
Joan testified that Peter did let him out. And
Peter would occasionally let him out, is what she did testify to that. But
she did.
I
But
thought
when
they
she
were
was
unique codes. They weren't.
When she
Did
was
you family
interviewed,
member?
the first time she was interviewed by, I believe it was Paul Klein, she said that didn't happen. But anyway, it certainly didn't happen frequently enough for a kid who doesn't live home to think that the dog was let out between 2 and 3 in the morning, when it didn't happen in the previous 15 days. And so what that told me was that was giving some insight that Chris knew what time that alarm was shut off. Really, is there a dog? Now, maybe I'm wrong. Are there dogs that have that sort of clock that between 2 and 3? And maybe there are. But if they are, I would think it would happen more frequently. And I would think that Joan would have talked about it and Jonathan would have talked about it, and they didn't.
I don't know how Paul Klein could have talked to Joan, because he was out of office by the time she could talk again.
No, he interviewed her at Sunnyview.
Yeah, I
Really?
think in December. I
Right,
think there was
and
an
then-
interview in December.
Right, and
Yeah.
the neurologist said that it was an improper interview, and
Yeah,
that
there's
Paul,
that.
and that they didn't do a neurological testing before, and that was a worthless interview. And Paul Klein, as we remember, is the person who had John Polster literally barred from the room for
That
8
wasn't Paul
hours.
Klein. Paul Klein wasn't there. That was myself and Mike.
Well,
So it wasn't Paul Klein. He's not here to
Okay,
defend
then.
himself. That was the call we made, and nobody barred John Polster from going in. We said, if Chris says he's his lawyer, you have to let him in. And they didn't ask the right questions.
What was it about
who didn't ask the right questions?
The
police.
detectives.
Yeah.
Right.
the screen?
Oh,
the
come
screen
on.
window in the garage, Mike. What was it about that? There was something. It was cut, but I thought the window wouldn't open all the way or something. So there was a.
So,
Was it-
so the earlier investigation where Joan's laptop was stolen, one of the screen windows, the screen was cut, okay? And the police thought that was the means of entry to the burglar who stole Joan's laptop. In investigating the murder, the screen in the garage window was cut, okay? So there was like a commonality. Like if this was an intruder, we've got the cut screen when an intruder got in one point in Thanksgiving, I think it was,
That's right.
the year before, and then the cut screen in the garage at the time of the homicide. But the cut screen to the window in the garage, Peter had drilled a hole, 2 holes through either side of the sash, and put bolts in so that you could only lift the window up so far. So if somebody forgot to lock it at night, that if somebody pulled it up, they weren't going to get it all the way up. So that cut screen could not possibly have been a means of access, but it was, a kind of a red herring that we suggested that Christopher left to make it look like somebody had broken in, except he didn't realize that, Dad had basically secured that window. So if you cut the screen, you're not going to be able to get the window up.
You can see the thought process as it operates here, because anything that doesn't fit their theory is clearly not true.
Well, no, I think it fit perfectly with our theory, because he staged the burglary to steal Jones' laptop, and now he's staging this to make it look like it's an intruder that came in and, butchered his parents.
If we had
That's great.
6 or 7 hours and you all had a lot of patience, we could talk about we could talk about uncharged crimes evidence, or what they call Rule 404B in the federal courts. It is a methodology or a set of rules and laws concerning the kind of information that can be shared with a jury about a person who's in trial. And the main thrust of it is to prevent a jury from receiving prejudicial information, such as, this is exactly what he did before. That's the problem here. So.
I just would like to say something, that I'm just really impressed that there are this many people who are involved in the community, and clearly you can see that our buttons are still pushed here
Still connected.
about this. But I do just want to say that, particularly now, and we were talking a little bit about this when we were meeting while you were all getting settled, and that now with social media, I think it's even worse. But even at the time that this happened, there were blogs, and we had death threats. We had to send our children away. People screamed at us in the grocery store to tell us that Christopher was guilty, or that he should take the stand, or he shouldn't take the stand, or he should be killed. My mother died during the course of this trial, and Terry had emergency angioplasty. And I will say that, as you can imagine, the 4 of us tried this case to the extent of our abilities, and both Mike and Dave were more than gentlemanly when I was going through this trauma. But one of the things that happened was my nephew, who was very, very close to my mother, when my mom died, as you can imagine, it was incredibly traumatic. And
that was right in the middle of the trial.
In the middle of the trial, people wrote in the blog that I had faked my mother's death so that I could get an adjournment. And I'm Jewish, which means that generally the funeral happens very quickly. Terry ended up in emergency angioplasty the next day. So we were literally calling Mike and the judge on the phone, and my sisters were saying, you have to stay with Terry, and Terry was saying, you have to go home to your mom to sit Shiva. And I was like, can I just go to Gold Canyon Ranch and forget about this whole thing? But it was incredibly stressful for us to be in the community where our friends and neighbors were, and some of them were wonderful and very supportive of us, and others were literally screaming at us, threatening us, and oh yeah, my poor nephew put a link to the obituary in the blog to prove that, in fact, my mother had died. I was just like, Jeremy, do not engage. But I just want to ask that, all of you are obviously engaged and care about this, to just realize that this is our ethical obligation, which we're very honored to support the Constitution, to support our clients. And obviously, you probably all came in here very strongly believing, probably most of you, the prosecution's side, at least that's the people who screamed at us most, but to just realize that it's a very difficult situation, that any one of you or your family members could be charged with a crime, and that you need to have very ethical, competent lawyers on both sides of these cases. And, I just appreciate those of you who've come here.
I have to share with you, you know, Laurie and I frequently discuss the absolute subliminal joy of being a criminal defense lawyer.
That's why we're retired.
So, and this was still relatively the early days of email. It was just getting started. People were using dial-up and whatnot. And shortly after the trial, shortly after my client was convicted, I got this email, and I've saved it so I could share it with you all here tonight. Somebody anonymously wrote me, and it said, "Porco is guilty as hell, and you're a terrible lawyer because you couldn't get him off."
So and we'll finish up now, and thank you all. But one of the most devastating witnesses, probably for the prosecution, came at the very end, and it really just kind of, the neighbor who lives down the street and can't stand the kid, 20-something kid, who drives 50 miles an hour up the street all the time, because a lot of people have that. So he had a reason to notice this yellow Jeep. And I think he was on a construction job, so he would get up very early in the morning, 4 a.m., and was leaving for work, and his testimony was that, oh, that kid's back, because he saw the Jeep in the driveway. And you ended, I know, your prosecution on that. I think that, resonated with that jury. But I remember from covering the trial in Goshen, the deliberations were not very long at all, just hours. And you're there for 7-8 weeks. You get to know the court officers, and they're limited. They're near the jurors. And there was a note that came back in the middle of the afternoon. And one of the court officers stepped out of the second floor courtroom, and he was in front of me. And I said, "Is it a verdict?" And he just said, he looked at me and he went. And I thought, wow. So I walked to the end of the hallway, and there was a window looking out on the intersection in front of the courthouse. And this is before iPhones. I had a phone that didn't have a screen. There was no tweeting or anything. I had to call the newsroom, and I remember I said, there's a verdict. And I said, and Christopher pulled up at that moment at the light, and he was in his yellow Jeep coming back from the hotel to the courthouse. And, I had watched every moment of the trial, and I remember I just looked down at him, and I thought, that's it. Because I felt like the verdict was so swift that I didn't think it was good for him. And he came into the courthouse, and as the verdict was read, I was sitting behind him, and I remember I could see his neck turn maroon, as anyone's would, as his blood pressure went up when guilty came out of the jury. And they remanded him, of course, and they were going to bring him back to Albany County in a jumpsuit. His freedom was over. But I had asked our photographer at the end of that, there was news trucks everywhere, there was people gathered everywhere, and I said, we got to stick around till everyone's gone. And he said, why? And I said, it was Mike Farrell, and I said, because that yellow Jeep's going to be sitting there all by itself. And I remember he took that photo, and it was just such a powerful photo, to see at the end of the day in this giant parking lot. It was nothing there but Christopher's yellow Jeep, and God bless their family. I know that we talk about the job that you all do. I have the highest respect for these people up here. I have been involved with them in many cases, and all of them are a testament to the things that are right about this country. I will say that. But, and at the end of the day, it's sometimes easy to forget, even as the years go by, the devastating impact this had on a really beautiful family. That was, but guys, I can't thank you all enough for coming, and I thank you all for coming out on a weeknight for this and taking part. Stay tuned, and We hope to see you at another event soon. All right, guys. Thank you. Enjoyed it. Thank you. All right.
Reopen that case up, give me a call, you know where to find me.
Okay.
It's a blue sedan.